Hello and welcome to another video from the Cambio Descomplicado channel. Today I want to talk to you about letters of credit. Let's go over the basic concepts and important things we need to pay attention to when dealing with letters of credit, whether for import or export, okay? So we're going to go a bit further, understand some concepts, regulations, and talk a little about this topic that a lot of people have been asking me about. And now we want to take advantage of the channel here to clarify things and answer your questions. So pay close attention to the next slides. I'm going to show you some slides so you can follow along with the material, all right? Shall we get started? Very well, so we're here this morning to talk about letters of credit. And the first thing I'd like to highlight here is that a documentary credit consists of a transaction in which a bank, which we call the issuing bank, acting on behalf and at the request of an applicant, also known as the requester, guarantees payment to a third party. This third party in a letter of credit is called the beneficiary. However, for the beneficiary to be entitled to receive the funds from a letter of credit, they must necessarily comply with all the terms and conditions of the letter of credit, okay? So that they do not lose liquidity, meaning they can receive payment from the issuing bank. So a letter of credit is nothing more than a means of payment through which an issuing bank guarantees, ensures payment to an exporter, to a beneficiary of the letter of credit, provided that this beneficiary fulfills all the terms and conditions described therein. So I also want to say that the letter of credit is a common payment method because it offers guarantees for both the exporter and the importer. Why is that? Because on one hand, the importer knows that the bank that is issuing the letter of credit is in fact including in that letter of credit all of their conditions, because the letter of credit reflects the commercial contract, and it is also based on a contract for opening the letter of credit where the importer tells the bank everything they want the bank to include in the letter of credit. On the other hand, the exporter also feels more at ease when receiving a letter of credit because they know that upon receiving it, they will have to comply with the terms and conditions. But if they fulfill all these terms, they are entitled to receive payment from the bank that issued the letter of credit, or even from the confirming bank, which we will discuss later, which is a bank that guarantees payment in case of insolvency of the issuing bank, or even in the event of risk-related issues, the country where the issuing bank is located. But for now, what we need to know here is that the letter of credit is beneficial for both parties, because the importer only pays if all the terms and conditions are met, right? Actually, the bank pays and the importer reimburses the bank. And the beneficiary also knows that if they fulfill all the terms and conditions, they are entitled to receive the funds made available by the letter of credit. So it's a very well-known and widely used payment method all over the world. And it is governed by certain regulations that we will discuss in just a moment. Therefore, the letter of credit is a widely used and very important payment method for international trade. We say that it is a conditional payment order because the exporter will only receive the agreed amount if all the agreed requirements are met, as I have already mentioned. One thing we need to keep in mind as a general consideration here is that both the importer and the exporter should be well aware of all their duties and rights established by the legislation, which governs the letter of credit, which is the UCP 600, right? So the UCP 600 is a book. It contains uniform rules and practices for documentary credits, and every letter of credit issued must include the clause. It is subject to the same UCP. It is not mandatory, but it is considered good practice to always subject it to the UCP 600 because these are the most widely used rules and standards in the world. And if there is any commercial dispute in any court in the world, the judge would use not only the local laws, but also these principles to judge the case. And it is specifically designed for this kind of thing, the UCP 600. So why does an exporter usually require a letter of credit? Because they want to protect themselves from the commercial risk related to the importer. And often they also want for it to be confirmed because they also want to protect themselves from the country risk of the issuing bank. So having a confirmed letter of credit is something very good for the exporter, especially if the confirmation is in their own country, so they can avoid the risk cross-border. It's important to mention that brochure 600 from the ICC, which is the International Chamber of Commerce in Paris, the organization that creates these rules for the whole world, It's important to say that this brochure is not above local laws. It does not supersede the local laws of each country, okay? But they are very important uniform rules and practices to govern letters of credit worldwide. So in general, a documentary credit or letter of credit, as we're calling it here, needs to be issued by one bank and advised by another to the exporter. This way, the exporter, who is usually not part of the SWIFT messaging group, can be sure of the authenticity of the letter of credit. Usually it is issued through the MT700, which is the standard message for opening letters of credit. Remember that there is also a SWIFT message for corporates, for companies, but this specific one is not available to companies. That's why a bank needs to issue it. So later on, we will go over the steps of this important payment method in detail. The professional who works with letters of credit must be aware that they need to know the following international rules. UCP 600, which has 39 articles and has been in effect since 2007. ISBP 745, which are actually rules, practices for examining letter of credit documentation. In other words, it provides a guide for you to check the documents presented under a letter of credit. The ISBP 745 is a supplement to the UCP 600, right? So it has been in effect since 2013. Before that, we had the ISBP 681 and the ISBP 645. Before the UCP 600, there was the UCP 500, the UCP 400, and the UCP 290. And from the time of the UCP 400, right? So there's also the EUCP, which is the electronic UCP, because it deals with the presentation of natively digital documents, or it allows or sets rules for when a letter of credit permits the presentation of part of the documents in physical form and part in digital form. It's still not widely used here in Brazil. So for an LC to be covered by these international rules, it needs to state that it is subject to UCP 600. When you mention this in the letter of credit, it is automatically also subject to the ISBP 745. And at times, SWIFT messages are used, right? For letters of credit. Normally, only 700 and 701 with the complement of 700, 710, 711, 720, 721. But later on, we'll talk about each of them. All right, there is one comprehensive document, which is specifically the SWIFT user manual, that thoroughly explains how to effectively utilize each of these important messages and the precise rules applied, including detailed usage guidelines for every single one of them. Well, it's also very important to explicitly state that we can indeed exclude any specific article in a letter of credit from the universally accepted UCP 600, for example, as per the established regulations. Now, when I alter or exclude any article from the UCP 600, they said, this letter of credit is subject to UCP 600, with the exception of such and such article. The related article in SBP 745 should also not be applied when checking the documents. And the current version is just a complement to the articles of UCP 600, right? I'm talking about the SBP 745. The current version of SBP 745 is just a supplement, right? That's why it can't be used on its own. No one checks a letter of credit by applying only SBP 745. You will always apply UCP 600 and 745 also as a supplement. Well, as for letters of credit, we have a few types of letters of credit, right? So let's see what they are. Regarding the type of commitment, it is either irrevocable or irrevocable confirmed. Special credits, we have revolving letters of credit, the red clause, which we call red clause, standby letters of credit, which are not exactly a documentary letter of credit. It's actually a guarantee called standby, which is different, right? The standby is quite different from the letter of credit. They are completely different mechanisms, but it also serves to guarantee a beneficiary in case of default by the importer, the applicant, the drawee, or the guaranteed party. If he doesn't pay, usually the beneficiary of the standby uses the standby to receive the funds. There are also transferable letters of credit, the transferable credit, and back-to-back credits, which are two letters linked for a triangular operation. Regarding availability, we have the restricted letter of credit, which we will discuss in the future about the restriction of the letter of credit, the types of availability, and here it is freely negotiable. And what are the parties involved in a letter of credit, right? Normally we have the importer, in fact, always, right? We have the importer because he is the applicant. He is the applicant, the one who requests a bank to issue a letter of credit. We have the exporter, who is the beneficiary of the letter of credit, right? The holder of goods or services, correct? Remember that the letter of credit can also cover services, and the issuing bank is the one that issues the letter of credit at the request of the importer, right? It establishes a counterparty limit. The importer provides a line of credit and guarantees payment to the exporter. That's why, even if the importer does not pay the bank, if the documents are presented in good order, the issuing bank is obligated to pay the beneficiary against those documents as long as they comply with the terms and conditions of the credit. And the advising bank, which is a bank that usually receives this SWIFT message and will notify the beneficiary in a physical form by email or by making it available in their internet banking or with digital certification. The fact is that it only notifies delivering this letter of credit to the beneficiary. There is the nominated bank, which is a bank already chosen by the issuing bank to represent it, and it is to this bank that the exporter should, in theory, deliver the documents to be examined. The negotiating bank is a bank that, whether nominated or not, is the bank to which the documents are presented, and it purchases the letter of credit and undertakes to pay, or pays at maturity, pays if it is at sight, undertakes to pay at a later date if it is a term payment, accepts drafts. All of this we will see later on. The confirming bank, as I mentioned, is the bank that adds a payment commitment to that of the issuing bank. In other words, it is the bank that tells the exporter, if the issuing bank does not pay you due to a risk issue, such as country risk, border closures, entering into a moratorium, or even if there is insolvency or default of the issuing bank, I guarantee payment to you. So when you have a confirmed letter of credit, the beneficiary now has a commitment and their main risk is with the confirming bank. But generally the issuing bank pays. However, if it does not, there is the option of the confirming bank, which also guarantees the payment. And obviously this costs more. Someone has to pay the confirmation fee. The confirming bank is taking on the risk of the issuing bank, right? Not only commercial risk, but also the risk of its country. The reimbursing bank is usually the issuing bank's cashier. It's the bank that will actually make the payment at the request of the issuing bank. The issuing bank asks the reimbursing bank to reimburse the bank that requests reimbursement there, or in case it is not present. In the letter of credit, the issuing bank expects the bank channel institutions, which have checked the documents, to send a payment order. The reimbursing bank is not a mandatory bank in the letter of credit, but if there is one, it will have the role of reimbursing the bank that requests reimbursement abroad. And then most likely the reimbursing bank will debit the issuing bank's account, because it is usually a correspondent bank of the issuing bank. The paying bank can be any of these, the bank that makes the payment to the beneficiary. The drawee bank is the bank against which the draft must be drawn when the letter of credit requires a draft. Not every letter of credit requires a draft. For example, when the letter of credit is available by deferred payment, it is a term operation without a draft. So, folks, here we have some important definitions before we talk about issuance. Article 4 of UCP 600, for example, states that the terms of the letter of credit are independent from the sales contracts or any other contracts on which they may be based, even if the LCA expressly refers to them. We never recommend that the terms of the contract be included in the letter of credit, in the sense of copying the contract. Inside it, or even if you mention the commercial contract, any judge will always rule on the letter of credit based on what is written in it and not on the object to which it may be referring. Here, with letters of credit, we work with the terms that are expressly written in the letter of credit, right? And for this reason, the importer and exporter must carefully consider which documents should be required and by whom they should be produced, and the time for presentation. The letter of credit will state the amount where the shipment will take place, and a series of other things that the exporter must comply with, especially the documents that must be presented in order to receive the funds it guarantees. So another thing, the issuing bank should discourage any attempt by the importer to include copies of the contract, as I mentioned, pro forma invoices or other similar documents as an integral part of the credit instrument. Remember that banks deal with documents and not with goods, services, or the performances to which they may refer. So banks don't know what's happening at the port. They have no idea what's coming. In the container shipping process, banks typically deal with various important documents. Banks will meticulously judge the entire process based on the specific documents presented in the letter of credit, ensuring strict compliance. Even if there are fraudulent documents, if the bank doesn't know, if the document appears to be in order, even if the goods do not match what is stated in the document, the bank has no way of knowing. The bank works only with documents, okay? One important thing when opening a letter of credit is that the issuing bank must provide complete and precise instructions to avoid the risk of ambiguity. So the clearer the instructions, the better in a letter of credit, right? They avoided excessive detail when issuing letters of credit. I used to work in the 1990s at a company called CCE. Some of you might remember it, Compañía de Componentes Electrónicos, and we would open letters of credit that were 9 pages long, 9 SWIFT messages, because there were electronic components coming from abroad, and they would list them all in the goods description. Each of those components, there were thousands of them. And that only complicates the process because it's very easy to make a mistake in the documentation and create a discrepancy. So any one of those components could cause a lot of discrepancies, right? That's why the Paris Chamber of Commerce itself says, look, don't include excessive detail in the description of the goods, okay? All instructions for issuing or amending a letter of credit or a credit instrument must clearly specify the documents against which payment or acceptance is to be made. The negotiation must be carried out. This is what we call a non-documentary condition. We have a condition stipulated in the letter of credit, but it doesn't specify which document will show that it has been fulfilled, right? That's the name given in the commentary. A condition means that every time you include an instruction in the letter of credit, you must require a document that proves the restriction has been met. Otherwise, it becomes a documentary condition, a non-documentary condition. All right, so in this case, it shouldn't require the presentation at the time of negotiation of documents that are issued, signed, and countersigned by the importer. We should warn exporters that if they receive a letter of credit under these conditions, they should request an immediate amendment if the commercial negotiation allows for it. Here, for example, when the exporter in Brazil receives a letter of credit, they have to prepare documents, but if one of the documents depends on the signature or certification of the importer abroad, this makes things much more difficult because that's how it is. We should discourage it, right? If possible, they should request an amendment, but there are cases where it's just not possible. We see that sometimes it's just not possible, right? But if you depend on documents that need to be countersigned by the importer and the importer abroad doesn't sign, you can't present them here in proper order to the bank, and therefore you're at the mercy of the importer. This can be a risk in the negotiation. And as for the revocable credit, even if there is no mention of its irrevocability, it is irrevocable. A letter of credit is irrevocable regardless whether we say it is or isn't irrevocable, okay? Article 3 of UCP 600. So we use MT 700 and 701 as a reference, as they contain all the necessary fields for issuing a documentary credit. For each field covered, we can comment on the rules from the brochure, okay? That's what's important, right? How do you fill out each field based on the UCP 600? So to redefine, a letter of credit consists of an operation in which a bank, the issuing bank, acting at the request and instructions of the importer, who is the applicant, guarantees payment to the exporter as long as the latter presents the stipulated documents in accordance with the terms and conditions of the credit. And then when we talk about a letter of credit or any operation, cross-border, international operation, transboundary, as some friends like to call it, you have the risks involved. The commercial risk is determined by the nature of the parties involved. So the exporter will always be taking on the risk of the issuing bank, not the importer. In a letter of credit, the issuing bank takes on the role of paying in place of the importer. So this is the exporter's risk. And they're also taking on country risk and even political risk, which also stems from country risk. Country risk, right? Political risk leads to an increase in country risk, right? Well, so the exporter is also exposed to this type of risk from the country where the issuing bank is located. And here we see a basic flow of the letter of credit where you can see the importer and exporter. First of all, so in the contract, the exporter usually asks the importer to open a letter of credit. The importer goes to a bank that will grant them credit, approve the credit limit, and charge a fee because there is capital allocation involved here. So there will be a request, a contract along with the annex where the importer will provide the information so that this issuing bank or issuer, however you want to call it, can issue a letter of credit and send it to a bank that will act as the advising bank for the exporter regarding the letter of credit. With the letter of credit in hand, the exporter, of course, ships the goods and will present the documents to a designated bank indicated by the issuing bank. Or if no bank is indicated, the exporter can choose a bank that they wish to use to present the documents. This bank will check these documents to ensure they comply with the terms and conditions of the letter of credit. And it will send them to the issuing bank, which will conduct another review and will present any discrepancies to the importer if it finds any, or it will say, look, the documents are in good order. If it's at site, it will request payment. If it's on term, it will deliver them to the importer, expecting the importer to pay at maturity. But at maturity, if the documents are in good order, regardless of whether payment has been made, the issuing bank will make the payment or should make the payment, or at least that's what it should do, right? To make the payment to the beneficiary. Very briefly, that's the flow of a letter of credit. I'll just show you what it looks like here. You can see here, right? Here, this is the Swift user manual, and you can see the fields here, right? Letter of credit, all of this has to be filled out. The M here means it's mandatory. These are required fields. The O is optional, meaning those fields don't necessarily need to be filled in. So you can see here the size, right? Of a letter of credit with all these fields up to field 72. Here, the sender to receive information where you state that the letter of credit is subject to CP 600 and SBP 745 and even RR 725, which is another topic for another time. All right. I hope you have enjoyed this lesson, this content. It's a quick overview, just laying the initial groundwork. The letter of credit course I usually teach lasts from 15 to 18 hours, but here it's just what we call an overview, just a general and basic look at the letter of credit. All right. So I'll see you in the next video. A big hug. All the best. Don't forget to write there, if you can, in the Descomplicado field. Click on the bell so you can receive notifications. All right, I'll be waiting for you. A big hug. See you soon.